notice of which I have given to yourself, to the Cabinet Secretary for Justice and the Minister for Parliamentary Business, as well as a copy of the draft speech. I should say that for 45 years I have been a solicitor, although I am no longer in practice. Last Thursday, the 5th of February, in the case of Hirst against the Chief Constable and the Crown Office and Procurator Fiscal Service, in a seminal judgment, Lord Lake of the Court of Session issued a judgment in which he found Scots law to be in clear breach of the European Convention of Human Rights and Fundamental Freedoms. He found in particular that Scots law unjustifiably restricts the right to a free trial. He even took the step of issuing a formal declaration to that effect under Section 4 of the Human Rights Act 1998, specifically that Section 170 of the Criminal Procedure Scotland Act 1995 is inconsistent with the ECHR. Such declaration was judicially described as a last resort. Now, Section 170 requires, inter alia, that for a case of malicious prosecution, this was what this case was about, for it to succeed, the pursuer must first have suffered imprisonment. Now, this is plainly ludicrous. Of course, it's correct that the Crown must be immune where they simply make a mistake. Not every case results in a guilty verdict. Mistakes can be made, prosecutions brought forward in good faith. But the law should surely not protect those cases where it can be proven that the prosecution was brought out of malice. That blanket immunity which Section 170 provides is what led to Lord Lake, I believe, making his finding. Now, the pursuer, Mark Hirst, a former STV journalist and prominent supporter of the late Alex Salmond, was prosecuted for an alleged breach of the peace for making comments which the Sheriff found simply to be an expression of an opinion. The Court of Session found that Mr Hirst had a relevant stateable case for malicious prosecution to go to proof, but because of the terms of 170, the Court's hands were tied and the action could not proceed, and Lord Lake could not consider the proof, even although he found there was a stateable case. So, because he was acquitted, the pursuer, Mr Hirst, cannot succeed in a subsequent case of malicious prosecution. It seems to me that Section 170 is our own legal version of a catch-22. I'll take an intervention just in 1 minute when I finish this point. Section 70 is our very own catch-22, not written as a work of fiction by Joseph Heller, but by the UK legislature in 1995, so that Mr Hirst, in order to proceed with this malicious prosecution action, would have had to said to Sheriff Paterson, "Please find me guilty and please send me to jail, because otherwise I can't pursue a case for malicious prosecution." This is plainly absurd. Justice was served and done by his acquittal, but justice was also then denied because of his acquittal. Presiding Officer, the right to a free trial is a cornerstone of democracy. It is what protects the citizen against the knock on the door at the middle of the night. It is what protects people from unlawful detention. It is what protects people from the jackboot of totalitarianism. Democracy is based on personal freedom, and where there is no fair trial, freedom does not exist. I'll take intervention from Mr Kerr.
I would just say at this point, of course, this item of business is to seek changes to future business, and it is important that that is borne in mind. Liam Kerr.
Well, perhaps I may assist in, Presiding Officer. I remind the Chamber that I too am a practising solicitor. Clearly, if Scots law breaches the right to a fair trial under the ECHR, that needs to be remedied without delay. So what does the member suggest that the Chamber do about it?
Fergus Ewing.
Well, indeed, and I'll just cut to the chase then, Presiding Officer. I appreciate, and I've communicated to the Minister of Parliamentary Business, there's not enough time for a bill. There would need to be massive consultation on the bill anyway, and I recognise that. But it must be done, nonetheless, as expeditiously as possible. We cannot allow a breach in the right of a fair trial, the most fundamental one of all, to subsist for any longer than is absolutely necessary. Therefore, My request, Presiding Officer, in conclusion, is that the Scottish Government, perhaps in the next couple of weeks, make a ministerial statement, and if in that statement they can indicate to the Chamber that they believe that this remedy must be cured, and it will be cured, then we can have confidence that this is a Parliament and a Government which does believe in personal freedom, democracy and the rule of law.
Thank you. I now call on Rachel Hamilton.
Thank you, Presiding Officer. Having given you prior statement of notice of my intent to speak, I rise in relation to the business programme to ask that parliamentary time be